Number 1, Cuomo versus New York State Commission on Ethics and Lobbying in Government. Counsel?
May it please the court, Dustin Brockner on behalf of the commission. Can I have 3 minutes for rebuttal?
Yes.
The third department held that because the commission enforces ethics laws, the governor must be able to control the commission through appointment and removal. That categorical rule suffers two fundamental defects.
Isn't it more than the third department? Isn't it the Constitution that holds that we have separate branches of government who each have their own independent function? And that an encroachment by one against another is a violation of our constitutional law?
That's correct at that level of generality, that our Constitution has that separation of powers. But the premise in there is whether that separation requires that the governor be able to control the executive branch through appointment and removal.
Well, do you think that the executive has to control, oversee, dictate in any manner?
There has to be, yes, under separation of powers, one branch cannot steal for itself the power of another branch. And the commission has a carefully structured appointment and removal process to ensure that it's sufficiently independent so it could do its vital job, and also at the same time prevent any one branch from usurping for itself the functions of another.
So no one controls the commission. It's extra government.
Not at all, Your Honor. There are ways in which the governor and legislature, there's political accountability through the commission structure. The governor
in what way?
And I'll go through them. First, the governor and the elected officials appoint the commission members. Through the executive budget, the elected officials decide every year how much funding, if any, to give to the commission.
But can we just follow up on that a little bit? We'll follow up on all of them, but on the budget specifically, doesn't the act itself prevent the governor from reducing the appropriation altogether?
No, that's not right, Your Honor. What Your Honor is referring to is something called interchange. That is a provision, and in this respect, the commission looks identical to the Board of Parole, a statute that plaintiff agreed to as governor. And what you're talking about is after an appropriation is made, after the governor decides how much and the legislature approves, after that, there's a statutory process not required by the Constitution where at times interchange lets, I don't know the details, for certain functions, money can be transferred from one appropriation to another. It is not constitutionally required. And instead, the key point here is the governor still has in her discretion as author of the executive budget to decide how much money, if any, in the first instance to give to the commission and what it can be used for. And if you look at the budget bills since then, even as to interchange, the governor has retained the ability to decrease funding at times.
I didn't mean to cut you off. What about removal authority? Can you point to any other agency where the members are removable only by impeachment or by a vote of the members themselves and not by any publicly accountable official?
I'll just give you one example. Most recently, Delgado, the committee there was no way to remove the members. It was the appointments were by statute, and there was no mechanism.
Although Delgado is arguably different in that there is, I'm not sure that there's the same type of executive authority that's being exercised. So maybe I should ask a more precise question, which is, any other entity that has exercised executive authority, if we were to agree that what the commission does here is to exercise executive authority, where there's no removal power exercised by any publicly accountable official. And I guess my follow-up question is, why shouldn't that trouble us?
Two responses on that. Well, first, Delgado, it wasn't a legislative power. It was a committee. It was quasi-legislative. It was still an executive function in that regard. And
well, wait, in what regard exactly was
it was rulemaking. It was something. It was authorized by statute. It was akin to rulemaking, which is something that agencies do. But I want to move on from Delgado. But that is an example where this court looked under separation of powers at a commission structure, and there was no removal, and it was held to comply with separation of powers. The Commission on Prosecutorial Conduct, there are no way to remove a majority of the members there. I believe the chief judge and legislative leaders appoint, and there's no removal mechanism specified for removal
So
of
let me
those
ask,
positions.
let me ask you this. Suppose we thought that the structure here was constitutionally fine. Is there a limiting principle on what types of executive powers could be delegated to a similar organization?
Yes, there are, Your Honor. And I'd like to go through 3 factors that a court could consider. And mindful, just to start, this court has never said, and it would be inconsistent with our history and practice, that the governor must be able to control every executive entity through appointment and removal. That's just not been our history and practice to date. And the factors, though, a court could consider to ensure that the legislature hasn't taken for itself executive power are, first, for an agency that's independent, does the agency's mission warrant the degree of independence, such as if it's performing an internal oversight function? Second, does an agency's structure provide adequate safeguards to guard against legislative domination? And third, did the governor consent to that structure, and does she retain meaningful influence over the agency's direction?
But if those are the factors, then it seems to me that you're arguing, but tell me if I'm overreading it, that there are no teeth to appointment or removal power, that if there are other safeguards, as you describe it, or some control, for example, through the budget process or the general supervisory powers, that's enough. I guess I thought you were making a narrower argument which had to do with the function of this particular entity.
I will, and I think that's what I started with. What is the mission of the agency? And it is unique here. I mean, this is not policing the public at large. This is the governor and the legislature deciding for themselves how to best regulate their own affairs.
Why help me understand why that matters in terms of the parameters of executive authority. I understand your argument, but I don't see, other than you pointing to Cohen and Delgado, a constitutionally grounded reason why that matters.
Well, those are constitutional decisions of this court.
They are, but if we thought they were distinguishable, I'm asking from first principles what.
It's a recognition of the political branch's institutional expertise and authority to decide for themselves how to best regulate their own affairs and operations.
So can I tell you what concerns me about that? It seems to me that separation of powers and in particular, some teeth to the authority that each branch has is partly about public accountability. And if I'm trying to understand why the self-regulation argument would allow us to discard what otherwise might be some checks, unless you're arguing that this structure would be permissible across the board with respect to any function whatsoever. So maybe you can help me with that.
Okay. I mean, there's several things to unpack from there. We are not arguing that this applies across the board. And I think internal oversight function is a key consideration in this case. And the respect for the governor and legislature's considered judgment that when it comes to how to best regulate themselves, they have the expertise and authority to make those decisions, with latitude. This is not the regulation of police function.
But within constitutional limits, right? I mean,
Yes.
any sitting governor could cede away constitutional authority under that approach and say, look, I agreed to it by not vetoing legislation. So would this legislation be unconstitutional if the governor had vetoed it and they overrode the veto?
I think that would be a closer case. And I think ultimately it would still pass muster, but I think it would be a different case for 2 reasons. First, unlike Delgado, where this court was clear that one consideration.
Delgado's a delegation case, right, which is a separation of powers case, but it's the legislature delegating its own authority. And the question there is, can they do that? This is another branch encroaching on the authority of a separate branch, sometimes I think referred to as reverse delegation, which the argument is should get heightened scrutiny from a delegation case.
Actually, I'd like to just address why there's no encroachment. So because of that factor. So you start with the function, and then you look to what is the degree of control. And let me just go back quickly to the veto point. If the governor vetoed, then we wouldn't be able to say the governor has agreed that this is the best way to self-regulate. So that would be, that's one of the reasons.
Can an individual cede institutional authority under the Constitution?
Not framed at that general, not some core power as such, but that's not.
The problem with your drilling down, to me, seems to be that you focus on each one of these things, appointment, removal, the function, the veto, and say not at that level, but it seems there is a very good argument to approach a statute like this from that level, which is how do these pieces work together? So how does the limit on appointments, how does the inability to remove, how does the function of disciplining a branch, which implies certain coercive mechanisms, and the fact that you have just an individual governor choosing not to exercise a negative here, don't we look at all of that and say, given the function, given the parameters that have been placed on it, given appointment, removal restrictions, does this somehow offend what this court has described as bedrock principles of separation of power?
I agree with that. It is a context-specific approach that looks to all those factors. However, this body strikes a careful balance. If we just take a step back, we know what happens with an ethics commission when it is not sufficiently independent. It is unable to do its job. It cannot help protect the public's trust in government. In fact, if it's thought that it's under the thumb of the political branches, it erodes the public's trust in government.
And is there a political price that would be paid for that?
Yes, but also the governor and legislature can address the problem and decide based on hard-earned experience, unfortunate
You would say,
experience.
though, that power to discipline within the branch is a formidable one, right? Power to discipline members of a branch, which I would think would have led in some way to the legislature deciding they would not be bound by this commission's decisions, that their recommendations that then go to the legislator's own internal mechanism, rather than what's been placed on the executive branch here, which is that they have the power to fine, right?
Well, two responses. First, you said it's for formidable power, but there's a formidable state interest in having an ethics monitor that is able to do its job.
On all branches or one branch?
Well, taking a step back on both branches, the commission has jurisdiction over both branches.
But can't do, its powers are very limited with respect to the legislature. I mean, tied to the function argument that you're making, I guess, is a question for me along these lines, which is, what do you do about the very broad scope of the statute's coverage, right? You, I think, are making an argument that this is self-regulation, internal management, right? But the breadth of individuals and officials who are covered is pretty substantial, including even lobbyists and clients of lobbyists. So how is it that the need for some independence on the theory that the executive cannot reasonably police oneself, how is that makes sense in terms of the much broader coverage in the statute?
Well, I think one point is the alternative is, this is plaintiff's theory. Despite that broad coverage, I mean, this is a facial challenge, despite it goes over lobbyists, legislative officials, only one person, the governor, has to be able to control through appointment and removal. And
No, but I'm asking you, though, if you're making an argument, which you said you're not arguing that this would be tenable. I'm sorry, Chief, I know his light is on, but you're saying this, you're not making the argument that this would be permissible across any function, and you're focused on the ethics function. And I took you from your briefs, although tell me if I misunderstood, to be focusing specifically on the executive and the governor's challenges, any governor, in self-policing oneself. But the coverage of the statute goes far beyond that. So how do we sustain it on the basis that you're proposing, given that it covers a much wider range of individuals or officials?
Well, it's independent of those, it's sufficiently independent of those officials. Well, I mean, the AG has an appointee, but doesn't control it. The point is that for the executive branch, a lot of those people are, the governor would want to protect as well. I mean, if there's, in addition, there's the AG and the controller. So I think it matches that when we're coming, when
I
there's
mean,
internal
if the
oversight,
statute were
there's
to
concerns.
be more closely tied to the problem that you're identifying, that might make for a stronger argument, I would think, that it was, necessary and therefore within the play and the joints that our separation of powers cases allow.
It has oversight over both branches, and it is independent, sufficiently independent of both branches, in that neither can dominate it. And the governor, I mean, I thought we started this conversation talking about the governor's influence, and she has powerful ways to influence but not unduly control the commission, and that's through the executive budget, which has been called one of the most powerful managerial tools that the Constitution
I
assigns to the
think that
governor.
what Judge Halligan is trying to ask, although maybe I may be misunderstanding it, is how does your self-regulation argument fit with the reach of the statute to lobbyists?
Just two responses, which is preliminarily, this is a facial challenge, so it doesn't matter the claim. It doesn't matter if it's the lobbyist or the governor or the legislature. The commission has no investigative power. That's the first claim. But to the point of lobbyists, they have a special relationship to the political branches, the governor in particular. They are trying to directly and expressly influence the behavior of the political branches. So it is necessary to regulate them if you're going to ensure ethical decisions are being made, that we are also, there's coverage for the lobbyists who are trying their level best to influence those decisions.
May I ask
So-
one quick question?
Yes, both.
But the statute says it's exercise powers and duties with respect to statewide elected officials, right? That could also include elected Supreme Court judges, the way that it is written now, because I, for one, am an elected statewide official. So how is this narrowly, this language tailored only to people in the executive, the executive branch, when it says statewide elected officials?
Because, Your Honor, I've never, this is sort of a new
Right,
consideration.
exactly.
Can I just point out Article 6, which deals with judiciary? This court has said that is the exclusive mechanism for disciplining judges. So that is the bulwark, and this court could.
Except now the legislature has said something else, right? So,
Well, no, sorry, you have to read a statute in context and understanding that when it says statewide elected officials, it's referring to the governor, the controller, executive.
Well, usually
officials.
statutes spell that out, but I have a different question for you. Can you point us to any authority that says the salutary purpose of legislation overrides separation of powers?
No, but the premise of that question is we're arguing policy, and we're not. We're arguing respect for the institutional authority of the political branches to say, when it comes to ensuring our own internal practices are ethical, and we have a functioning ethics monitor, the political branches have the latitude to design the monitor as they think will work. So that's one thing. But then second, purpose or the reason for a law is certainly relevant under this court's separation of powers doctrine. In Cohen, this court found relevant the law was designed to attain a paramount state interest.
Not at the expense of another branch of government, though. That's my point.
But this is not at the expense of another branch of government.
This is an encroachment, arguably, one branch encroaching on the quintessential function of another branch to execute the laws. I mean, these are bedrock principles that we teach our middle schoolers from 6th grade through high school, through our law school classes in state government.
So I actually think, and you are referring to bedrock principles for sure. The question, though, is appointment and removal an essential part of that? And in New York, It's never been vested exclusively in the governor. She has other managerial tools like the executive budget, like her investigative power. And here she also
Okay,
has.
let's talk about the investigative power. We talked about the budget, and I think it's toothless. I know you tried to defend that, but ultimately, the governor, the act itself says the governor, in the interim, between appropriation, cannot reduce the amount of money that the commission gets. But let's talk about investigation. Let's say there is an investigation. What happens next?
The governor can investigate, make clear, I mean, sunlight is a powerful antiseptic. The governor, this is all in the context of all her powers combined. She investigates the commission, makes subpoenas, witnesses, takes testimony, makes clear the affairs of the commission, then uses the bully pulpit to make clear what her
Okay,
findings are.
then the commission
And then
rejects
through
that.
the budget.
Then the commission rejects it.
I'm sorry, who's the commission in that question? I'm sorry.
The commission rejects the investigation done by the governor.
So Colleague, the Ethics
Yes.
Commission? Well, that's not the commission. The Ethics Colleague doesn't have any ability to reject a Moreland Act Commission's
Oh, you're saying that the
findings.
governor has retained her power to investigate, correct?
Yes. And including investigating Colleague. I'll call it Colleague for purposes of this question.
And I'm
So
asking, what happens after that investigation?
the governor can make clear what her findings were about how Colleague is expending its funds, making its decisions. Then she can, through the bully pulpit, go to the legislature, explain if what changes need to be made. And also through the budget, she could say this commission is not using its resources in an appropriate way, and use that as the author of the budget. It's a powerful, powerful tool that's been recognized
Okay,
to
and-
influence it, but not control, because may I finish?
Yes,
this?
of course.
Because we saw when the governor or the elected officials, this is through JCOPE, if you give them too much power, if you give them removal, there will be a perception that the that the elected officials are using the commission to protect themselves, and that in this context, based on unfortunate experience, the political branches said we need it to. The political branches have oversight over the commission, but not undue influence that would prevent them, that would impair the commission from
One
doing its
more.
job.
That antiseptic quality, that could be true for the commission as well, right? They don't need the power to punish and the power to enforce fines, because they also have this antiseptic. They could have that antiseptic effect. They have a bully pulpit. They could just say, you know what, that we found X findings, we're going to air those out, sunlight is good, without encroaching upon a quintessential executive power of punishment.
Or in another way, that same question, what's the justification for the difference in enforcement mechanism between the legislature and the executive? Even your theory.
If I can, I guess let me see if I could take this in turn. What's been struck down by the lower courts is the entire investigative power, so it's not just the civil penalty provision. If there's the flaws of civil penalty provision, that the court should focus on that. But as to the difference, and I'm going to talk about the difference of the Legislative Ethics Commission, I hope to explain why the penalty power is also
But if the
constitutional.
theory of
Yeah.
this commission is, as you described, what could be the justification for a different enforcement mechanism? Because then, to Judge Singus's point, isn't the fact that the commission can do Part A without having the enforcement power of Part B enough? If it's enough for the legislature, why is it not enough for the executive?
Taking a step back, because under JCOPE, that's when the scheme was
Forget
created.
JCOPE.
Yeah.
I just want to know here in what you've just said, because we never considered JCOPE, this statute, what's the justification for the divergent enforcement mechanism?
Because experience with JCOPE showed that when the investigative step is constrained, when it's the JCOPE, when the
Only
elected
for the
officials-
executive, though.
No, for both. So the elected officials have too much control over JCOPE. Then that's where the problem was. So they fixed JCOPE with the commission. If problems arise, if there's similar concerns with the
Could you
Legislative
answer,
Ethics Commission.
my question is, what under that scheme then, a bad JCOPE experience, which I accept, justifies a different enforcement mechanism for the legislature than for the executive? If Part A is the antiseptic and the investigation and the referral, why do you need Part B for the executive and not the legislature?
Why? Because at this point, experience had shown that if the investigation is controlled by any of the elected officials, that will be quashed. And the point is,
But
there is no,
legislatures aren't elected?
we're not, I think it's this is again internal control, and if there's problems with the Legislative Ethics Commission that are akin to the problem with JCOPE, if experience shows this model isn't working, the political branches can do what they did here and tailor the response
So I'm
to
a
fix
little
it.
unclear. Is your
And-
point that the experience with JCOPE was that the legislators could police themselves, put aside the investigation, but punish and police themselves, but the executive branch could not?
No,
Okay.
the point is, just 2 points. Just because the Legislative Ethics Commission has a certain structure doesn't require that the commission have a similar structure. That's just the fundamental point.
Well, does the
why.
will the former governor even have standing to complain about that here?
For,
To complain that, well, they get to police themselves, but I don't get to police myself?
no, I'm not sure I fully understand. The point, though, is that the problem at hand was because JCOPE could, this two-step process where there's an ethics monitor that investigates, and then it goes to the Legislative Ethics Commission. That was under JCOPE, and that was the scheme. And after a decade of experience, it was this scheme is not working, but the problem was not the Legislative Ethics Commission is shirking its duty. There's no evidence that the commission, JCOPE, found a violation, and then the Legislative Ethics Commission decided not to impose a fine. There's no evidence like that. Rather, the concern was at step 1 of the process, which is with JCOPE. So they tailored.
But there was that concern with the executive branch? That JCOPE was finding these violations and referring them to the executive branch, and the executive branch was taking no action?
There was, no, the concern was at the investigative stage that the control was more
Okay, but then.
insidious than that and prevented the investigation
But you're
in the first
missing the
place.
call of this question. The question is, okay, maybe you've made a good argument about investigation, but why is it then you can't have the independent investigation with the recommendation, as is the case with the legislative branch, for the executive branch to then clean house? I think that's the nature of these questions.
I understand, and that's because the separation of powers is not a mechanism for the court to tell the political branches how to fine-tune their internal control mechanism. It's to ensure that the
No,
legislature.
but you said the purpose of this is important to the constitutionality, and if the purpose is inconsistent, wouldn't that affect our analysis of the common good argument that you're making? Because, as Judge Rivera articulated it better than I had been doing, there didn't seem to be a problem with that part of the enforcement. It was with the investigation. So why do you split Part B this way? Because certainly the power to impose these penalties is significant.
And the power is significant, that is true, and because the political branches took this an incremental step. I mean, JCOPE itself was a change from the prior regime because we were unable, as a state, to have an effective ethics monitor. So the way to fix it was through JCOPE, and when the problem with the new scheme, which is JCOPE and the Legislative Ethics Commission, the problem was with JCOPE. So then the targeted solution was with JCOPE and creating the commission itself, and the governor made the decision that she doesn't want, and partnering with the legislature, she doesn't want to be able to unduly influence the commission.
We've said in another case, and I can't think of it, you can't cede your constitutional authority because you don't want to be accountable, right? I mean, that's a political accountability issue.
Right.
And you can't say, I don't want to make that decision because,
And there's as much, if not more, political accountability than the commission found accountable in Delgado, and that is through.
Can I just clarify one, I know we've gone way over on your light,
Yeah.
I just want to clarify one thing. Is there anything in this legislation that prevents the executive from doing their own investigation and, let's say, terminating an at-will employee in the executive branch? Is there anything here that prevents them from doing that?
No.
Can I ask, in the briefs, my understanding was that a severability question was raised and it was briefed, but decision on it was reserved. Is that right?
That's correct, Your Honor.
Can you tell me what your view on severability was before Supreme Court? Was there any provision that you thought might, make the statute, as I understand you're telling us it's constitutional in its entirety, but under Supreme Court's ruling, constitutional?
I think there are two responses. One, that if the issue is with the enforcement, the fining, then that's the part that's Executive Order 9410P. That can be severed and the remainder of the statute could be upheld. Or alternatively, that the commission exercises lots of powers besides investigating enforcement, collection of financial disclosure statements, training. Those are powers outside 9410, Executive Law 9410, and those powers, the commission can continue to provide training and continue to collect financial disclosure statements and lobbyist registration statements, and it can continue to do that. And I think with respect to severability, and assuming this court did find a flaw, which we submit it is not, that it would be very precise to guide the court's analysis, and also because this would be the first time in New York's constitutional history that this court has had separation of powers prohibits an agency structure from being done in a certain way.
Thank you.
And I will reserve the remainder for rebuttal.
Thank you.
Good afternoon. May it please the court. Gregory Dubinsky on behalf of respondent, former Governor Andrew Cuomo. Over 2 centuries ago, James Madison said, "I conceive that if any power whatsoever is in its nature executive, it is the power of appointing, overseeing, and controlling those who execute the laws." This court has enunciated a similar principle. In this state, the court has said,
So if the executive still gets to do that, which was my question to him, where is the, as he called it, stealing the authority of the executive branch to also provide an independent entity who would investigate and perhaps impose civil penalties?
I'm sorry, I'm not sure I understood the
Well,
question.
the executive still gets to do that, right? That was my question to him. Or do you disagree? Do you believe that the executive could not, regardless of what this agency does and chooses not to investigate perhaps something, that an executive, right now Governor Hochul, could decide, I'm dissatisfied, or I think there's corrupt conduct, I'm going to terminate the employment of this particular individual in this branch?
So what the act at issue does is it creates an entirely unaccountable law enforcement agency.
Well, just to be clear, do you agree, as he answered me, that the governor still has that authority?
What I'm trying to say to Your Honor's question is,
Well, it's a yes or no.
well, no, because COLA gets to decide in its unilateral discretion who to enforce the law against and what penalties to impose. And the governor does not get a say in those enforcement decisions.
No, and I understand your point about that, but independently of that, doesn't the executive still have authority to otherwise clean house?
I think it's conceivable, but I think that's completely irrelevant to the constitutional question.
Well, let's say,
before us.
I don't know that's true, but okay, that's a fair response. So let me ask you this. Let's say this particular entity did an investigation and cleared someone. Could the governor still decide, I'm not going to continue with that employee?
It's conceivable, but again, to take the inverse of Your Honor's question,
Yes.
if COLA decides to enforce
Yes.
the laws against a particular
And
individual.
Hochul would not, right?
Right, and again, this reaches not just executive branch and legislative branch officials who cannot be punished, but also private individuals, right? So if COLA decides, I'm going to enforce these sweeping, use my sweeping powers as an agency to punish individuals for violating the ethics laws, the governor does not have any say whatsoever in that, cannot oversee those individuals, cannot remove the members. So for example, if COLA just decides to treat.
And that's because of the enforcement authority over the law, not because these are employees within the executive branch, correct?
Correct, because the act imbues this commission with sweeping, mighty law enforcement powers are quintessential executive powers to
I
decide.
want to,
Yes,
go
Your Honor.
ahead, finish.
To decide who to punish, for what conduct, and what penalties to impose with no oversight whatsoever by any official. This is a quintessential case.
Would it be constitutional if all they did was recommend to the governor? We've done our investigation, we recommend, we think it's substantiated, we recommend the following. You
So-
decide what you're going to do with it, but this is our recommendation.
Obviously, that would be a different statute, but I
Yes,
think
I understand, I'm asking you,
I
would
know.
you say that's constitutional?
I would still say that that intrudes upon the governor's prerogative to decide who to investigate and to determine how enforcement is conducted. As I was going to say earlier, and then I would like,
Well,
you know, to
why
make
does
sure.
why does it do that?
I'm sorry?
Why would Judge Rivera's hypothetical do that? I mean, the newspapers are recommending things to the governor all the time.
Well, the newspapers are, of course, not state
No,
agencies.
they're not, but if it's simply a recommendation by a state agency, the government's free to disregard that, no?
I agree that it would present a different question than the.
Well, an unconstitutional problem or one that,
I still think that it would intrude upon the governor's.
Well, how would the legislature be taking for itself the enforcement authority by merely having an entity that is recommending the governor's action, but the governor makes the final decision?
Right, but what, in the hypothetical we're discussing, the agency would still be empowered to make determinations about whether a particular individual has violated the law.
And the
if-
governor
if-
can
and if-
conclude otherwise.
Well, not exactly, because.
Governor's not bound, in my hypothetical, the governor was not bound by any of that.
Right, but you're still having an unaccountable commission saying, Ms. Jane Smith has violated the law, right? That itself is a mighty power.
I want to make sure I understand your view on removal. So is it that the governor has to have sole and exclusive removal authority, or can the authority be concurrent with the legislature? What's your position?
So I think the question of removal power as it pertains to executive branch officials, so as it pertains to executive branch officials who are exercising quintessential law enforcement functions,
Well, I take it you're arguing here that one of the flaws in the statute is that the governor does not have removal authority.
Correct, Your
Right?
Honor.
Okay, so my question is, what is the nature of the removal authority that you believe the Constitution confers? Is it exclusive, or can it be concurrent?
right, and with respect to quintessential law enforcement executive officials, it is exclusive.
Officials or authority? Quintessential, what do you mean by quintessential law enforcement officials?
With respect to executive officials who exercise quintessential executive functions,
I'm just asking about the commission. I take it you mean you're characterizing them that way?
correct, yes,
Okay.
Your Honor. So with respect to those sorts of officials, I would say it is an exclusive authority, except I would say, and just to be clear, because I think our position has not been totally correctly represented by my friend, we are not contending that the governor has an indefeasible power of removal and appointment over every single executive official.
That's what I'm trying to probe.
And
So on removal, what are the parameters you would say?
So the legislature can say, for example, that certain officials can be removed only for cause.
Uh-huh.
So.
Presumably, or to require an explanation,
To
something like
require an
that?
explanation, of course, the Constitution.
But your view is that the removal power itself, even if it can be conditioned, can't be shared and can't be concurrent?
That's-
So if we set aside, if you would, the federal cases, I know you rely on those, but if you would set those to the side, what's your best support based on the constitutional history and our case law? I know you rely on Gooden, but I believe that's a case in which there was an express authority that was given to the governor. I don't think we have that here. So what's your support?
So actually, if you read Gooden carefully, the description of the governor's power in saying that in this country, the power removal is an executive power, and it has been vested by the people exclusively in the governor, that cites Article 4, Section 1, which is the vesting clause, of course,
Yes.
which is not, a reference to the specific provision.
Okay, fair enough. But in addition to Gooden, what would you
In addition to
point us
Gooden, I would
to?
say, as Chief Judge Cardozo has explained in Richardson, which we also cite, the removal of an executive officer or a public officer is an executive act. And so I would say that also is an explanation.
But can you, so I guess two related follow-up questions. The first is, other than Gooden, and I take your point about Cardozo's comment, but I'm not sure Richardson directly presents the question we have before us now, despite that comment. But are there cases in which we have said that the governor must retain removal authority?
I think I pointed to what, in our view, are two
Got
Court
it.
of Appeals cases that present that point quite in our, strongly. And I would just say, again, on Gooden, it really does I think stand for the broad proposition because it cites expressly to the vesting clause.
Understood. And in terms of the constitutional history, right, I do think that there are distinctions between the way in which appointment and removal were treated under our Constitution and various proposals for change as opposed to the federal Constitution. So in terms of the back and forth over the last 200, whatever it is now, almost 50 years, what are the historical points, data points that you would ask us to look at in support of your view of removal authority?
I'm glad Your Honor asked that question because I think it's a key point. So my friend argues that, and this is on page 20 of their reply brief, that the vesting clause in Article 4, Section 1 and the take care clause in Article 4, Section 3 imbues the governor with no authority over appointment or removal, which is an extreme argument, because in the very beginning of our constitutional history in the state, the Council of Appointment existed alongside those clauses. Now, it's a bit ironic in our view, and I'll get to the larger exposition of the history, because even in the Council of Appointment, the governor had a say, among others, in terms of appointment and removal. My friend's position is...
But I believe, correct me if I'm wrong, that then Governor Jay actually put the question of whether or not the governor had exclusive removal authority, and the answer was no. So I'm not sure how the Council of Appointment stretch is helpful to your view, at least on appointment, but maybe I'm missing something.
Yeah, what I'm saying is that the governor had a seat on the Council of Appointment, and so had a voice, a vote among others on the Council of Appointment, but the implication of my friend's position is the governor has even less power now than he or she did under the Council of Appointment, which is, not, in our view, nonsensical. But just to explain the history a little bit, obviously the Council of Appointment was abolished. And although the state constitution did imbue the Council of Appointment with some executive power for a time, it was abolished. And later there was some language which we think has been overread that allowed for the legislature to create, to decide the method of appointment of certain officials. We think those are local officials, and indeed the constitutional text, which my friend relies on, has been repealed. That was in 1963. And the only provision that my friend relies on in the entire history of our state's constitution are, one, the Council of Appointment, which we've just discussed, and two, language that now reads that as regards local officials, that local government can determine how those officials are appointed. So I think the meaning of executive power, which I refer to, in the beginning of my remarks with respect to James Madison, is a well understood principle, what the executive power entails.
So then, does your proposition have to rest on the vesting and take care clause? Is there any other place where there is an affirmative conferral of, maybe set to the side appointment, but focus on removal authority on the governor, or do you have to derive it from the other two clauses?
I didn't, so two things. I didn't get to discuss Article 5 yet, which I think is very important here, but I would also say that it's not just the vesting of the executive power in the executive, it's also the vesting of the legislative power in the legislature, not of the executive power in the legislature. So we obviously have a separation of powers in the state, although it is somewhat modified versus the federal constitution. The legislature still is not given any power to remove, in our view, state executive officials. But moving forward to Article 5, so the constitutional history...
If I can just go back, since you can see that the executive's removal power can be cabined by the legislature, for example, you gave one example, there may be others, by having a for-cause requirement. Why isn't this a constitutionally acceptable cabining by saying it's only focused on particular violations, these ethic law violations, in the service of this greater good, because that is a way that addresses what didn't work under the prior framework?
So I would have a few responses to Your Honor's question. Sure. So first, the Constitution says that the governor shall take care that the laws are faithfully executed. That is a undifferentiated grouping of laws, the laws, not the laws except for the ethics laws or the laws except for whichever laws that the legislature decides is expedient to allocate enforcement authority to independent commissions. So that's point one.
Well,
But-
except that the response to point one might be, well, the best way for the governor to take care that the ethics laws are effectively enforced is to turn that enforcement over to somebody who's not self-interested.
I think that that's a policy choice that the act makes, but, and a particular governor might, make that determination. This case is of course not about, whether that would be a good idea or not.
Well,
but
Cohen does have some concern about what the policy is, no? In its constitutional analysis.
Cohen has some stray language about the
you
fact
call
that
him.
the legislature is conditioning its compensation is salutary because it serves the public interest, but I don't think that was key to its
It
decision.
does say that the intent matters,
Well,
right?
even if the intent here is high-minded, the policy choice that's made by this legislation is different than the policy choice that's made by the Constitution of the state. The Constitution of the state says that accountability is very important. We have a chief law enforcement officer, a chief executive, that's the governor. If the governor does a bad job, and I'm not quibbling with, whatever perception of the prior agency has been argued, there's a democratic check on the governor's take care
Yeah,
authority.
but the question is whether or not there can be any other check. It's not that, of course, you can, as they say, vote the bums out, right? That's not the issue. Yes, that always exists, but it may very well be that the legislature and the executive decide that that is not good enough to address this particular concern, which is not only about ethics violations, but it is about the loss of public confidence in government.
So the second point I wanted to raise in response to Your Honor's question on this topic is a reference to a point that Your Honor raised in her dissent in People v. Davidson that was taken up by the court in People v. Viviani, which is the principle, dating back over 100 years, that where the Constitution establishes a specified office or recognizes its existence and prescribes the manner in which it shall be filled, the legislature may not transfer any essential function of the office to a different officer chosen in a different manner. So that principle, which this court has recently enunciated in Judge Garcia's opinion for the court in People v. Viviani, applies certainly as strongly here as it does to a county clerk, as in Wogan, which is, as this court has said, a principal function of the executive is to carry out the laws of this state. And as I was going to say at the beginning of my remarks, this court has also said that the executive is accorded great flexibility in determining the methods of enforcement.
But I guess,
So-
as I was saying before, why, let's go with what you said, why isn't the executive, since they can remove, they can investigate and remove, you agreed, on their own, enough, given the goal and the concern, so that we don't end up finding that this is unconstitutional, because the legislature has taken for itself, which is, I understood that to be your argument, legislature has taken for itself.
Well,
this
it's
power.
actually two arguments. One is the point about usurpation,
Yes.
because as we've argued, these are legislative agents who are empowered
Yes.
to enforce the laws. But the second and equally important argument is that this is an executive power, and so it doesn't matter if you transferred it to Joe Schmo.
The diminishment of the power, yeah.
Right, it's the encroachment upon the governor's take-care duty, which is essential. The implication of my friend's
Except
argument...
it's not wholly, it's not all of the power, because the governor can still investigate and remove or not remove,
I'm
whatever
not sure
person may
that's
have
right.
that way.
I'm not sure that's right, Your Honor. I think there would be some
If
serious...
we read the statute that way, what's your response?
that
Let's
it's-
assume we read the statute that way.
that it's still, I think in the People v. Viviani case, the question was about concurrent authority, prosecutorial authority. So that same principle would apply here. If we're going to have two law enforcement agencies, what is the chief executive officer of the state, whose job it is to enforce these laws, and the other is a completely unaccountable commission exercising tremendously powerful authority to punish whomever it decides, for whatever reason, and impose penalty, that would still be unconstitutional.
Counsel, I just have a clarification question on the statute. I'm a little unclear. How does it work when the commission finds that that an employment action should be taken against an executive branch member? So removal, is that mandatory, or is that then a recommendation to the executive to remove?
So the way the statute functions is, the colleague, in its unreviewable discretion, can impose a fine. In addition
I
to the
understand
fine, it can order termination or other discipline. It can refer the matter for discipline.
But it can't order that unilaterally.
I believe that it can refer it for discipline, but I'm not certain whether or not that is a mandatory. I believe it is. It's a referral for discipline. With respect, and this is another argument, it can also recommend impeachment for statewide officials. But it can still recommend discipline, termination.
Well,
in
and that
addition
would go
the-
to the executive branch if it's an executive official?
It's to the employer of whatever official is at issue.
And if they would be in the executive branch, so, okay, so let's just follow up on that. And then, is the official, who would be the supervisor or the agency or department, are they bound by the recommendation?
They may not be bound, but the person is still going to be liable for tens of thousands of dollars.
But in
a
terms of
fine.
termination, so then the executive would retain the authority of removal. And this boils down to the penalty.
Again, I think that the issue is whether an unaccountable law enforcement agency is permitted to impose penalties and to investigate whomever decides it should investigate
Yeah.
or decline to investigate, and impose penalty, decide that someone has violated the law. and impose-
Reviewable by an Article 78, yes? Is everything reviewable by a 78?
I'm
I
not
thought
sure
it
that the.
was, but maybe I'm
It is
overreading the
reviewable by an
provision.
Article 78. I'm not sure about if someone was then disciplined, whether that would be reviewable by Article 78.
Understood. And the
But
penalties, I thought the statute provided that the commission could impose them, and that would be a final determination as distinct from some employment action. Is that right?
Yes, that's my understanding.
And is there any way for the people to ensure that there's an independent ethics commission that wouldn't run afoul of a separation of powers?
Yes, Your Honor, I appreciate the question. The answer is by constitutional amendment, as was done at the Commission on Judicial Conduct. That shows the right way to go about setting up an agency like this that's independent and that has members of one branch disciplining members of another branch. If the people decide that it is good policy to have members of the legislative nominees and agents deciding whether or not executive branch officials should be penalized, they're free to do that by
But they
constitutional
have no
amendment.
power to police themselves.
The people have the power to vote out a governor who doesn't do a good job
No,
of.
what I'm asking you, you're saying, however, neither the governor nor the legislative branch just have the ability to police themselves. They have to go through a constitutional amendment and ask the people to set up a mechanism for saying.
I would modify what Your Honor said slightly. I would say that the legislative ethics branch can enforce the ethics laws against the members of the legislative branch. That's what currently happens. COLA cannot discipline or penalize members of the legislative branch by the statute. With respect to the executive branch can discipline itself, and if they don't do a good job, the governor can be voted out. And if
So
they
just to
would-
be clear, if the legislature, not this model, set up a model that looks exactly like this when it comes to anyone who falls within the legislative branch, but says, we're going to let that independent commission determine discipline and determine removal, we're not going to have it just be a referral to us. Would I assume you think that would be constitutional, because that's the legislative branch choosing a mechanism to to police itself, even though it's an independent entity.
If I understand the Honor's question, if
Yeah.
the legislative branch created its own
Yes.
mechanism,
Yes.
but it wasn't legislative appointees who were deciding how to penalize legislative,
Correct?
they were independent,
Yes?
you would remove the problem we have here with respect to one branch
Yes, no,
disciplining another.
that was my question. That was my question.
And I think that, one branch disciplining itself presents very different issues, and that is how, the right way of going about it. Whether or not they can empower, the legislative branch can empower private individuals to do that, I think is sort of not before the court, and I think it's different when the executive branch does that versus the legislative branch. And let me explain why I think there would be a distinction. Even if the legislative branch could say, we're going to put private
So
individuals.
can the executive branch enforce ethics laws against legislators?
I would say no, for the same reason that the legislative branch, as here, can't discipline
Well, the
members.
Attorney General can surely pursuant to statute, right?
Right, we're not talking about
And
criminal.
the Tweed law does that, I think.
Right, and we're not talking about criminal prosecution here. This is just about civil enforcement. So I would put aside the questions I'm not contending that, for example, the governor is immune from enforcement of the criminal laws, or that legislative, members are immune from the criminal laws either. My point,
Go ahead.
my point is a separate one, just to respond to the question. With respect to the executive branch, again, the executive branch is responsible for carrying out the laws, for determining methods of enforcement. So the governor cannot delegate that authority to
Well, that's what
private
I'm saying.
individuals.
Can
That's what I'm
then-
saying.
That's what I'm saying. Can then the executive branch investigate and decide the discipline against a legislative official?
And my argument would be that, no, each branch is in charge of disciplining their
But
own.
if it's the general ethics laws and the legislature writes it that way, what would be the problem?
Again, the separation of powers prevents the interference by
Okay.
one branch with the peculiar functioning of each branch's duties. So for the same reason that the legislative branch is
So it
not.
doesn't matter if the legislature writes the law that way, right? Because it's the supremacy of the Constitution that matters, correct?
Correct.
Okay.
You focused on the penalties. Does the investigative authority alone pose the same degree of intrusion on your view?
So as I was saying earlier, I don't think you can just sever the penalty
I understand that.
provision, because what we have here is essentially, for a number of reasons, the legislature wanted a watchdog with teeth. So
I appreciate your view on that. I'm just asking you whether you think as a matter of constitutional intrusion on executive authority, it poses the same kinds of problems, and if so, why?
So I think it's the ability to punish is obviously on a different
Mm-hmm.
level than other abilities. But I would still say that the power to investigate or decline to investigate whomever it pleases, and then the power to declare if someone has violated the law, is still a quintessential executive function. So the governor here is deprived of any authority to determine the methods of enforcement, which includes the power to decide who to investigate and who not to investigate, right? Which is a quintessential question of prosecutorial discretion. So I think we're
But in the
still-
civil context, is that quite the same? I mean, in the criminal context, obviously it is, but could the legislature set up a commission to investigate some set of problems, take your pick?
And these questions came up at Supreme Court as well. And there might be a different question about delegation of legislative authority to investigate, but that's not what we're talking about here.
But why is that? I think you just said that investigations are by their nature quintessential executive authority. So,
Sorry, what I meant by, just to make sure I'm being clear on that.
Thank you.
When they are conducted within the executive branch.
isn't that a little tautological? If it's
Well,
an
it is-
executive, branch action, it's executive.
Well, it's just as tautological as this court's precedent saying that the executive power has been committed to the executive
Okay, fair.
department, right? So that's sort of the
But you do
definitional.
think that the legislative branch could engage could set up some commission that would engage in investigations on a particular set of questions or activities?
Absolutely. Obviously, the legislature has fact-finding
Mm-hmm.
authority, and I don't quibble with that, but I think that's very different, right? The legislature, for example, can't pass a bill of attainder, right? Saying so-and-so has violated the law, we're going to punish this person, right?
But could a legislative commission not issue a report which takes particular individuals to task for their conduct in some, set of issues? I would think that would be hard to exclude if they can do it generally.
I agree, and that would be something that, for example, a legislative subcommittee could do. But again, we're talking about an executive branch agency here, and that does carry different weight. And again, going back to, I think Your Honor earlier had mentioned the question of political accountability. Political accountability in ensuring clear lines of political accountability is, after all, at the core of what the separation of powers is set up to do. So the governor is elected as the chief law enforcement officer, which is why, going back to Judge Rivera's questions, it is so important that the governor be politically accountable for her discharge of that duty. Similarly here, when it comes to who to investigate and what penalties to impose, even before the question of penalties, declaring that someone has violated the law, right? Saying this person has committed this misconduct, they've violated the law, even if it's then referred to the governor to decide what punishment to impose, you still have a diminishment, in my view, of the political accountability, that it's at the heart of the committing of the executive power to the executive branch. If the legislature creates a subcommittee that's tasked with investigating the conduct of executive branch officials and lambasts those officials for their poor conduct in office, the lines of political accountability are clear. It's the legislature that's doing that, and that's I think, an important piece of the constitutional separation of powers.
Thank you.
Thank you, Your Honor.
A few quick points. Chief,
Before you get to your points, I just want to clarify, is it your view for your client that indeed a colleague can make a recommendation for removal, but the executive branch is not bound by that recommendation?
for lower level employees, I believe that's the case. I am not 100% sure that the statute might be ambiguous in that point, and if it matters, the court can construe it accordingly.
It does seem ambiguous on that point, right?
It doesn't expressly say the removal decisions are binding, and I think the court can, again, if there's constitutional concerns, construe it accordingly.
The reports sent to the legislative body when there's a finding of a violation for a legislative employee, are those public?
Unless law enforcement requests otherwise. Yes, they are public.
They are public.
Unless it's for a specific law enforcement reason, they are public.
So the referral to the legislative branch is public?
That's correct, and there's a cite in our reply brief. I don't have it. It's in the legislative law, I believe. The chief law enforcement officer, my understanding, is the Attorney General, but we don't need to quibble about who bears that title. The point is, as this court has recognized in RAP, there are departments and agencies over which the governor has no general control.
That's an intra-branch separation of powers issue. That's a fractured executive issue. But isn't it very different to have an executive power go outside the executive branch? I mean, if you had given this authority to the Attorney General, it would have been a very different story than an independent commission, right?
Several responses. Again, I do want to keep sight of context here, which is the self-regulation. So we are not talking about vesting the police power to look at the police, the public at large, is again within the discretion of the political branches. But even then, there are still examples of commissions out there. We cite a few, Board of Commissioner of Pilots, that has this power and isn't controlled by appointment and removal by anyone in the executive
Control
branch.
license for the New York Harbor, right?
And impose
Pilot's
and seek
license.
penalties as well. So an executive power that Chief Judge Sanford said, this body doesn't absorb or interfere with the function of any executive officer.
So I looked, and that was really the only example I could find of something that was similar in terms of the, complete curtailment of appointment and removal authority. Maybe, let me ask you, is there anything more, having heard the discussion on the public accountability question, and whether or not the absence of both of those powers completely provides sufficient accountability? I appreciate you're saying there are other mechanisms through which the governor can continue to exercise accountability, but why isn't removal authority necessary for significant enough accountability?
For several reasons. First, this court has never held that, and I think it's reflected in Delgado, again, where there was no removal power. And then also because when the removal in this context is granted to the elected officials, we see what happens, which is the elected officials
But that's a
can...
policy point. I guess what I'm asking is, to my mind, separation of powers is a structural doctrine. And so I'm trying to understand why it is that the policy concern can allow us to kind of carve out an exception in the structural protection.
It's not an exception. Removal is just a tool. It is not an end in itself.
Well-
And it is just one of the tools that is not granted necessarily to the governor in overseeing in her role as governor.
Fair enough,
Yes.
but practice would suggest, I think, since we can't really identify examples other than, I know you say Delgado and pilots, we can't identify examples over hundreds of years where there is no removal power, even if conditioned, that the governor holds, I think. So practice maybe suggests that there should be some concern about whether that's necessary.
Well, I think a few things. So you cite some exceptions, including exceptions that this court has blessed. So, so as to whether this is a unyielding categorical rule that applies regardless of function, I think those exceptions strongly suggest it's never been recognized that way. And then in this context, when we were talking about the internal oversight and not necessarily the policing of the public at large, it was found that the political branches made this considered judgment, that this is a feature we need to, removal protection is a feature we need to have in order to make this commission independent enough to do its job. And there are large executive departments and branches out there where, agencies out there where the governor doesn't control through appointment and removal and instead has her oversight through the executive budget and through her investigative powers. And in this context, the commission strikes, according to political branches, it strikes the careful balance, and that is ensuring the commission's independent enough to do its job, but not allowing any one branch to take for itself the power of another branch. We ask the court to reverse and uphold Executive Law 94, 10, and 14.
Thank you.
Thank you.